I appear for the appellant with Mr. Richard Munden. My learned friends, Mr. Gavin Miller, KC, and Mr. Aidan Willis appear for the respondent.
Yes.
Mr. Banks is on business in South Africa, but he is watching on the live stream, and he has asked me to stress that his physical absence is not any sense of discourtesy to the court. My lady, before I start, there have been a couple of issues with the bundle, but I hope they've been corrected. Just the easiest way of checking it, we think at the bar, is to make sure that for the court, the title page of the judgment is at page 62 of the core bundle. And if it is, then I think we all have the same pagination.
Yes, in fact, I've taken my copy of the judgment out. It's quite a substantial document.
It is indeed.
And I think paragraph numbers might be helpful.
Right, I think we all thought yesterday when we were worried there was a problem that ultimately it was solvable because we were navigated by paragraph. And just the related point, can I ask whether members of the court in the authorities bundles are using soft or hard copies, because whether it's helpful for me to give you PDF page numbers or to give you tab numbers, or whether I should do a mixture of both?
I've got both, so probably.
I have only the soft copies.
You've got the, well, I will give PDF page numbers, but if any member of the court wants me to give a tab for the physical bundle, then of course I'll do so immediately.
I think I would find that helpful.
Well, I will certainly do that then, my lord. Thank you. My lady, this appeal concerns, as you know, two widely promulgated statements by the respondent. And at trial, the respondent did not contend that her allegations were true. In fact, she accepted they were not, and that there was no evidence of Russian money going to Mr. Banks. And I'm compressing it because I know that the court will have looked at the statement, so you won't need an exposition of precisely what it is that they say or what Mr. Justice Steyn found the true meaning to be. But as the judge records in her judgment at paragraph 7 and 8, the respondent eventually sent a private letter of apology, which the judge quotes. And the letter continues, and this is in Mr. Banks' statement: "I apologise for and withdraw the allegation. I confirm I have no intention of making such an allegation in the future." But the respondent has done nothing at all to bring that concession and apology to public attention. Both the TED Talk and the tweet remain live, and the respondent has continued to publicise the TED Talk since her apology, for example, by tweeting a link and referring to it in her crowdfunding appeals. And just at the outset, we say that the fact the judgment below permits this to happen, we submit as a preliminary indication that something has gone wrong with the outcome in the lower court. Indeed, even overnight, Miss Cadwalladr has tweeted to say, "Tomorrow Aaron Banks' lawyers will try to overturn a minor point of the judgment against him. What this can and cannot change, what this will not and cannot change is the facts. A High Court judge found Banks had a close and covert relationship with Russian officials in the run-up to Brexit." That's a tweet which in the 10 odd hours since it's been posted has already been viewed 224,000 times. And she follows it up immediately with another tweet referring to the UK government sweeping evidence of years of Kremlin influence operations under the carpet. So that is the position which, notwithstanding the judge's findings and indeed the letter of apology and the promise not to re-promulgate, in which Mr. Banks finds himself, the TED Talk and the tweet are still there. He has not received any damages by way of vindication. He cannot obtain an injunction. Now, as the court's aware, Mr. Banks' appeal really divides into two limbs. The first, with permission of the judge, is a full appeal on a point of statutory construction involving Section 1 of the Act, the Defamation Act 2013. And then there is then the rolled up permission to appeal application adjourned to the court by my Lord Justice Warby, on the judge's two specific findings in respect of serious harm, firstly for the tweet and secondly for the talk. Before I come to those three areas of contention, may I make three short general points by way of preface. Firstly, the respondent skeleton places much emphasis on the judge's observation that the TED Talk was an important contribution to a political debate of wide significance. Now, let me say immediately, we take no issue with that. The impact of social media on the democratic process, which was the main theme of the talk, is a serious issue all around the world, and it goes well beyond the Brexit referendum, as we all know. But this case, of course, has never been about grading the TED Talk as a whole, with its predominant focus actually on the activities not of Mr. Banks, but of Facebook. what we're narrowly concerned with is the gratuitous aside midway through that talk, in which the respondent falsely alleged that Mr. Banks had a secret and corrupt relationship with the Russian government, and her subsequent doubling down of that in the tweet. The second prefatory point is the judge, as you will have seen, accepted that Mr. Banks gave honest, open and ungilded evidence about the harm he believed he has suffered as a result of the false allegations and the distress which resulted from the subsequent social media furore. Now, as to that, the judge, of course, records, and Mr. Banks accepts, that he is a controversial public figure. He threw himself with gusto into a rancorous Brexit debate, and he, and if I can, meaning don't no disrespect, say frankly the respondent as well, both of them might fairly be described as polarising or Marmite in their public character, and inevitably for both of them that comes with some cost. But we do say that for all of the hearty debate about Brexit, which Mr. Banks might be described as having brought upon himself a certain amount of in some quarters, diminished opinion, but for all of that, there is a fundamental qualitative difference between being thought by a section of the public to have misguided or objectionable political opinions, and on the other hand, being presented as a bad faith political actor, a cat's paw, dishonestly acting as a hidden conduit for a foreign regime, and a foreign regime that is held in perhaps the lowest esteem of almost any foreign regime amongst the general public of this country. I mean, remember, all of this happened after the Salisbury poisonings. And whether the judge sufficiently recognised that, what we say, key distinction when considering serious harm, is a point that I'll, of course, return to when I come to the permission to appeal applications. But, and this is my third and last introductory observation, the judge did at least sufficiently recognise that distinction to find that Mr. Banks did have a genuine grievance for which he legitimately sought vindication by these proceedings, and reject the respondent's repeated allegations that she has been pursued abusively and oppressively by means of a so-called slap. My lady, having made those points, I'll come immediately to the point of statutory construction, if I may. The Defamation Act is the first tab of the Authority Bundle, page 2 in the PDF. And of course, separately, we have section 15, which was supplied at the request of the court yesterday. Now, so far as the 2013 Act is concerned, it makes important reforms to the law of defamation. But as Lord Sumption observes in Le Show, an independent print, it does so in a piecemeal and unsystematic way. And Lord Sumption clearly thinks that that's part of a somewhat regrettable pattern of parliamentary intervention into the common law of defamation over a number of decades. But so far as section 1 is concerned, the text is very simple. You'll see it's subheaded requirement of serious harm, and then it provides a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. And then that is glossed by section 15, which, as I've said, is supplied separately yesterday. And what section 15 says is first, I'll deal firstly with the definition of statement. It gives it a broad meaning. Words, pictures, visual images, gestures, or any other method of signifying meaning. But in this case, obviously, we're concerned with a statement which consisted of words. And then so far as publication is concerned, if I can gloss the gloss in effect, it says publication retains its common law meaning. And certainly as we understand it, all that indicates is that in the Act, publication means communication of the statement to a third party. Now, whereas some parts of the Act replace the common law, a section, for example, the justification defence is abolished and replaced with a statutory defence of truth. That clearly is not the case with section 1. It is essentially a super addition to the existing common law requirement for a defamatory statement. It's the only aspect of the cause of action which it addresses, and it doesn't address even that aspect comprehensively, because, for example, it says nothing about the relevant standard of opinion, but there has never been any suggestion that it interferes with the traditional common law standard expressed in various hallowed phrases like right-thinking members of the public generally. And indeed, as my Lord, Mr. Justice, Warby observed at first instance in Le Show, statutory language which is formulated as a statement is not defamatory unless, ellipsis, is simply not apt to constitute a new or a comprehensive definition. And as his lordship said in that case, which we don't have in the bundle, it is clear the subsection serves to add to the common law, not to substitute a different provision. Now, how does it add to the common law? In our submission, it's clear from Le Chaux it adds to it in a twofold manner. Firstly, it elevates the level of harm from the common law non-trivial to the statutory serious. And secondly, it elevates the necessary impact of the statement from the common law theoretical to the statutory actual. So common law tendency to harm is sufficient. Under the statute, there must be actual harm or its probability. And essentially, the former element stiffens the approach the common law had got to in Thornton, and the latter approach builds on the Jamil requirement for a tort to be real and substantial. And those two cases and no others are the cases which are specifically cited in the explanatory notes to Section 1, which again we don't have in the bundle, but we'll find it quoted in the case law in early course. The mischief to which Section 1 was addressed is evident from quite extensive travaux préparatoires, which I think is surveyed in some detail by my lord in his judgment at first instance in Le Chaux. But it's summarised by Lord Sumption in Le Chaux itself, which is tab 8. The relevant passage for those of us using the PDF is page 189. I'll give Lord Justice Singh, my Lord Justice Singh, the number in the report momentarily. So in the report, that's page 619 of the report. Where, if I can begin in the centre of the page, by marginal B, in the centre of the page, this is midway through paragraph 1. Broadly speaking, that's the Act, seeks to modify some of the common law rules which seem to unduly favour the protection of reputation at the expense of freedom of expression. In particular, there had been criticism of the state of the law in which persons resident outside the UK, with only a very limited reputation in the UK, were able to sue here for defamation and obtain substantial damages. One of the principal provisions of the new Act was Section 1, which provided that a statement was not to be regarded as defamatory unless it had caused or was likely to cause serious harm to the claimant's reputation. So the overall impact of Section 1, we say, is to introduce a new element to the test of a statement's defamatory character. And if I can look at just a couple of descriptions of Section 1 in the first instance authorities. Firstly, the case of Ames, which is tab 5, and I'm going to refer to paragraph 49, which is at PDF page 106. Which, for those without the PDF, is page 3423 of the report. So paragraph 41, this is Mr. Justice, it's my lord at first instance. This wording does not abolish the principles discussed above. It introduces an additional requirement. The use of the word serious obviously distinguishes the statutory test from the common law as stated in Thornton. The threshold identified in the Thornton case was the statement should substantially affect attitudes in an adverse way or have a tendency to do so. The Jamil test also requires a tort to be substantial. As Mr. Justice Bean noted in Cook, examination of the parliamentary history of the section shows the word serious was chosen deliberately in place of the word substantial. It follows the seriousness provision raises the bar over which a claimant must jump, as compared with the position established in the two cases mentioned. And there is then a reference to the explanatory note which I referred to a few moments ago. And you will see, as I said, that indeed refers to Thornton and Jamil. So the section builds on the consideration given by the courts in a series of cases to the question of what is sufficient to establish that a statement is defamatory. So the focus is on whether the statement is defamatory. A recent example is Thornton, in which a previous authority was identified as authority for the existence of a threshold of seriousness in what is defamatory. There is also currently potential for trivial cases to be struck out. In the Jamil case, it was established there needs to be a real and substantial tort. The section, that's section 1, raises the bar for bringing a claim so that only cases involving serious harm to the claimant's reputation can be brought. So it's presented there as a threshold requirement, and this metaphor of raising the bar in terms of a bar over which the ship must cross before it can leave the harbour, that is a metaphor which one finds in practically every single one of the subsequent decisions about the Act, or about section 1 of the Act. And I also in our skeleton we cite another decision of my lord, this time citing with approval the sort of pen portrait of section 1 that was painted by Judge Maloney QC sitting as a judge of the High Court. That is in the it's cited within Monroe and Hopkins, which is tab 6, and it's page 137 of the PDF, which is paragraph 69 of the judgment. So where an allegation has a seriously defamatory tendency and is widely published, the claimant may choose to rely on these facts alone, perhaps in conjunction with evidence as to the identity as to the publishees, as the basis of an inference that serious harm was actually caused. And I read that out because it's obviously going to be germane in due course to also to the permission to appeal application. That at one stage at least was the primary position adopted on behalf of Ms. Munro. In some cases it may be enough. It's certainly not necessary in every case to engage in detailed forensic examination. And then the specific passage which is really relevant to the statutory point is my lord's approval of Judge Maloney's formulation in the Thiedem case, which is the indented quotation at the foot of paragraph 69. It's important to bear in mind that section 1 is essentially a threshold requirement intended by Parliament to weed out those undeserving libel claims otherwise technically viable, but which do not involve actual serious harm to reputation or likely serious harm to reputation of the future, in the future. So my lady, my lords, reflecting this, and as this much invoked metaphor of a bar encapsulates, our submission is that section 1 operates as an in limine test to determine whether a statement complained of can be defamatory. It's intended to sift out unmeritorious claims which are not serious, either because, for example, they involve somebody without much reputation in the United Kingdom, or they involve somebody, they involve a publication whose presence within the United Kingdom is very small, the mischief that Lord Sumption identifies. It's to weed out that sort of case. And equally cases where statements are inconsequential. But it does so by the application of a one-off test, which is applied to the statement at the start. And the statement is the words, and the words don't change. So you take the words, section 15, definition of statement, you apply the test, and you either cross it or you don't. Has this publication caused, or is it likely to cause, serious harm to the claimant's reputation? So our respectful submission is that all that was required of the learned judge was to determine whether the relevant statements of the respondent, i.e. the talk and the tweet, were ones that had caused or were likely to cause Mr. Banks's reputation serious harm. If that test was met, the case could proceed, including to the point at which the availability of defences was considered. But if they didn't meet that test, the case doesn't pass the bar, it doesn't cross the threshold. And if I can add to the metaphors with Judge Maloney's metaphor, it is therefore weeded out. But that is the preliminary exercise. And we say approaching matters in that way is perfectly effective to discharge the statutory purpose of section 1, which is preventing actions being brought on statements which haven't caused and are unlikely to cause serious harm. And it removes from the scope of the tort statements which might just theoretically harm reputation, and so are defamatory at common law, but which have not and will not have serious real-world consequences, doing so by mandating this simple threshold test. Now, we know, of course, that the judge took a different view, albeit she expresses herself tentatively, acknowledging the point arises very late in the course of closing submissions in response to a question from her. But notwithstanding that, she obviously went on to make positive findings. and her ladyship didn't treat Section 1 merely as a threshold test to determine at the outset whether a statement had a defamatory quality. She treated it as an ongoing requirement, so that if certain publications of a statement were found not to be actionable because a defence was established in respect of them, the test of serious harm has to be applied afresh to the subset of publications to which the defence does not apply. And if I can take up her judgment at paragraph 56, which for those using the bundle for the judgment will be page 76 of the bundle, the core bundle I should say. So she begins 56 with some, well, essentially the shape of this part of the judgment is there's 56, which is the general paragraph, and there are 3 short specific points that she makes over then the following 3 paragraphs. So 56, having acknowledged the tentativeness with which she was proceeding and the lack of full argument, she begins by saying it's a matter of logic. The defendant must be right that any harm to the claimant's reputation that is attributable to a publication for which she establishes a defence ought to be disregarded if there is a significant change of circumstances such that the defendant ceases to have the benefit of the public interest defence. The question whether publication has caused or is likely to cause serious harm should be assessed from the date of that change. Now, just pausing there before I come to her 3 more specific reasons, we respectfully say, firstly, that does not follow as a matter of logic, because the question at which Section 1 is directed is in our submission whether a statement, namely the particular communication of the particular words, whether that statement crosses a threshold of serious such that it can be considered defamatory. And the statutory focus is exclusively on the statement and its actual or likely consequences. A statement which is a constant whose contents don't change. So one doesn't get into...
Mr. Williams, the consequences might change.
Well, as Lord Sumption, Lord Sumption's approach in last show is to say that in the vast majority of cases, the wrong will be done at the point of utterance or whatever it may be, however it's conveyed. And what happens subsequently is simply evidence of harm rather than the harm itself. That's the way that he puts it. But I obviously do accept that in some cases there could be a waxing or a waning of consequence. But that doesn't alter the fact that the initial judgment, it has to be whether the statement itself is or is likely to cause serious harm. Now, if on some occasions it doesn't cause serious harm, but it does on others, it's still a statement that has caused serious harm.
But it's not the statement that causes the harm. In the abstract, the statement, if it's not published, can't cause any harm at all. Yes. So it's got to be the statement plus the publication.
Well, it's got to be the publication, and we'll come on to the way that the judge deals with that. But you certainly do look at the consequences. And obviously an illustration of that would be the way that your lordship dealt with matters in Le Show, for example, where you looked at the circulation of the relevant publication and the readership statistics and things like that. So it is an exercise which takes into account consequences, but it's the consequences flowing from the statement itself, which is a constant.
Yes, but if one reduces it, suppose to a not entirely theoretical example where there are only 2 publications, same statement, 2 different people. One of those publications is seriously harmful. Let's say catastrophic for the claimant because it's made to his spouse or his business partner. The other is entirely harmless because the person to whom it's made doesn't understands the language but is in no way concerned with who the claimant is or what he's done.
Yes, or doesn't believe it.
So if it's the statement alone that's the criterion, then the second publication is actionable. And if the first publication is defended successfully on public interest grounds, you have a curious situation, don't you?
Well, the statement is, and I don't think you were putting to me to the contrary. Either publication is actionable because there has been serious harm, and in the assessment of serious harm, our case is you look at the statement and you look at its consequences. You don't look at that with regard to individual publications. You look at it collectively, and that's the way the approach has been in all of the authorities. So far as the existence of a subsequently established statutory defence in respect of one of the publications, then the fact that that particular publication had not augmented the damage that was caused by the publication that didn't have the statutory defence would be relevant, we would say, to the amount of compensation. It might not be at all relevant in your lordship's example, because the impact from the indefensible publication is so drastic. But the essential proposition is that it's a threshold test at the outset where you take the statement and you look at the real world consequences or the likelihood of them in a single once and for all exercise. It is not something which is subject to a constant review. You either cross the bar, in which case you're in the open waters, or you don't cross the bar, and you either don't leave the harbour or your ship sinks, whichever way you want to put it.
And that was the approach in relation to the common law, the approach of the common law to whether a statement was defamatory or not. But the argument is that things have changed now with the definition of, or the requirement of serious harm in Section 1, and therefore one can't adopt a once and for all approach.
Yes, well, of course, my lady, it's certainly not part of our case that things haven't changed. And one of the respectful criticisms that I make of the learned judge in due course, the first of her more specific reasons, she says, well, this flows because Section 1 was intended to be significant. Nothing we say denudes Section 1 of seriousness, because as I have accepted, it changes the common law position significantly in two respects. Firstly, it moves from a test of non-trivial harm to serious harm. And secondly, it moves from theoretical consequences to actually having to demonstrate real-world consequences, and those are both very significant things. So it's not part of our case that hasn't changed matters. But as law assumption also says in the show in general, unless there's some indications of the contrary, when Parliament alters the common law, particularly in a situation like this where it clearly has not done so in a thoroughgoing way, it has simply imposed a very focused super addition, as I've described it, onto the existing common law framework. It's presumed to change it to the minimum extent that's necessary to achieve the statutory purpose. And if the statutory purpose has been rightly characterised in the past as weeding out the inconsequential claim or erecting a bar which has to be crossed, then there is nothing in my analysis which disrupts that purpose, and there is nothing...
We are focusing not on the metaphors or the language that is used to describe the section, but actually the section itself.
Well, of course. Well, I agree with that. Well, let's forget the metaphors. If one looks at the section itself, as I say, it is about a statement is not defamatory unless its publication is caused or is likely to cause serious harm to the reputation of the claimant. Now, we say the focus is on whether or not the statement has a defamatory quality, and insofar as it refers to publication, that is an exercise which doesn't. I mean, and I'm going to come in a moment to the judge, and my learned friends very much support this. The judge's importation of Duke of Brunswick ideas about sort of divisible causes of action between independent utterances.
They're not divisible causes of action, individual causes of action that you
I
would aggregate.
Yes, I realised as soon as I said it that I misspoken, and I was hoping I got.
It's the other way around. That's the issue. Yes,
absolutely. Yes, I thought I got away with it, but you caught me. I did misspeak. But that, the exercise of whether publications cause serious harm in our submission, and I'll come to it in a little more detail, is something which has to be regarded and always has been regarded as essentially a collective assessment. You don't look at individual publications, and if you did, you could easily imagine a case where, in fact, no individual publication would be serious. Not the example my lord gave to me a few moments ago. But in a case where the very thing which causes the crossing of the bar is the collective scale of the publication.
Does it not depend on the circumstances?
Well, ultimately everything depends on circumstances. And for example, we're accused in my learned friend skeleton of saying essentially there is a rebuttable presumption of serious harm if you have mass publication. Now, we don't go so far as that, because it ultimately always does depend on the circumstances. Do accept that. But our submission, so far as the judges are bringing into account the defence is concerned, and you have in mind the existence of a defence when you're conducting the Section 1 exercise, so that you in fact have to conduct it again if a defence emerges and then leaves the scene, as it were. In our respectful submission, that isn't how Section 1 operates, because Section 1 doesn't depend on the availability of a defence. It simply depends on whether sufficient harm has been caused. So first you class the statement. Is it defamatory or not, having regard to its consequences or likely consequences? If it is defamatory, you pass through Section 1 for good. And of course, at that point, the question of defences may arise. For example, the statement may be defamatory but true. But once you get to defences, you have necessarily passed through the issue of whether the statement is defamatory, i.e. the Section 1 exercise. That's our submission. And we say with respect to the judge that it is in the very nature of a defence that it arises only when the ingredients of a tort have otherwise been established. Section 1 therefore is directed at an antecedent question as to whether one of the basic ingredients of the tort, the defamatory statement.
The issue is whether that's an all or nothing question.
Yes.
And the argument to the contrary is that you have to consider the publications as discrete ones.
Yes.
And you can't simply do it as a once and for all point.
Yes, well, that's the argument. Obviously, I acknowledge that, and that's the way the judge approaches it. But we say, that is immediately, we would say, begins to be inconsistent with any traditional understanding of the way a defence operates. You only get to a defence if you've established the tort. And Section 1 is all about one of the building blocks of the tort itself, namely the existence of a defamatory statement. And it is there as the filter to make sure the tort is only established if the statement itself has sufficiently serious consequences. And if it does, the question of defences may arise, and if it doesn't, you never get to defences.
I think the pivotal point in your submission is what you said a moment ago, that the question of whether a statement has a defamatory quality has to be considered as a collective, in a collective way, as a collective assessment.
Yes.
And it always has been.
Yes.
I'm not sure it always has been, because it's only since Section 1 came into force that we've had to look at this.
Oh, I think when I said it always has been, I meant since Section 1.
Yes.
Yes.
So we've got a relatively small number of cases.
We do have a relatively, we still have a piece of legislation that has just reached its 10th birthday. I do.
And I think they've nearly all been cases of mass publication. So we haven't had examples like the one that I put to you, although those cases are not
certainly there are some where the publications have been in the low thousands rather than the tens of thousands or hundreds of thousands. But I think your lordship is right to say that there haven't been any that I've read in the run up to this case where it's been a very localised publication. I can see that.
Because this situation where the public interest defence waxes and wanes, I don't think it ever waxes again, is quite an unusual one.
Yes, I accept that. I mean, it does happen. And one of the cases, of course, is flood, and that was a case where there was a defence and then there wasn't. So it's not something which is fantastically rare. But I accept that it isn't the common or garden defamation case.
Well, if the defence is truth, then it's going to be true.
It's not likely to wax or wane.
Wax or wane. I suppose it might happen in a case of honest comment.
It might happen in a case involving a former member of the royal family, but we've had yes.
Yeah.
Yes, I mean, it clearly is part of my case that ultimately the analysis of whether or not there has been serious harm is a one-off exercise, having regard to the consequences of the publication holistically. I mean, that is our case, and it's certainly the way it's been approached in the case law. But I do acknowledge, as my lord's just put to me, that in Lasho, for example, this issue didn't need to be considered. But certainly, I mean, the actual example that Lord Sumption gives in Lasho of a case that might, before the intervention of Parliament, have passed the threshold and now probably wouldn't, is the case of publication to a small number of people. Even there, one is looking not in any sense at the publication individually, but one is looking at its aggregate impact, the aggregate impact of the statement, not on the aggregate, not on the impact of the individual publications, which in legal theory are separate causes of action. Yes, so I think I probably come to the judge's three specific reasons. The first of them, I've really anticipated them, so that's 57. She says it was evidently intended as a significant amendment. It would run counter to the purpose of the provision if the claimant could surmount the serious harm threshold by bringing into account evidence of harm caused by lawful publication. I've already said our answer to that is we don't accept that is a valid critique. Our approach is not inimical to the statutory purpose of what's been described as weeding out or imposing a threshold. Threshold, as we've seen, that's the word that's actually used in the explanatory notes to the section itself. And our analysis, therefore, we submit, operates in complete fidelity to the statutory purpose. And as I've said already, it certainly doesn't deprive Section 1 of effect as a significant amendment to the common law for the reasons I've already given. Now, the next point the judge makes is at Section 58, where she makes the point that for the purposes of assessing damages, any harm to the claimant's reputation suffered as a consequence of publication is disregarded. See Le Show. And obviously, we don't dispute that. We don't dispute that principle. And the conclusion she draws from it is, in effect, that because Mr. Banks can't be compensated for any serious harm caused during the currency of a defence, it makes no sense for taking that serious harm into account when asking if the Section 1 threshold has been breached. And she says that follows from the words of Section 1 and its purpose, and also says she draws support from Lord Sumption at paragraph 24 of Le Show. But with respect to the judge, we say it doesn't flow from either the words or the purpose of Section 1, because they're directed solely to whether a statement is defamatory and whether it's caused serious harm, and always likely to. And moreover, the fact that it's common ground that damages are not recoverable for harm suffered during the currency of a statutory defence shows there isn't, in fact, any need to read Section 1 in the manner contended for by the judge in order to give proper effect to the statutory and other defences which are available to defendants. The partial availability of a defence is catered for by a judge's decision on damages.
You could have a case in which a very serious allegation was made with a limited audience, and steps were taken almost immediately to get an injunction, for example, to stop it. And in those circumstances, if the injunction was granted and there was no further publication, you could have a situation in which a statement surmounted the threshold, as you call it, in Section 1. There were good grounds for granting an injunction which became permanent, the action settled, but damages were limited because of the prompt action that was taken. So there's no necessary link between the amount of damages, it could be said, and the threshold requirement.
Well,
again, it comes back to the point which I made earlier, which is that it depends on the circumstances.
Well, in the example which the ladyship has posited to me, I mean, that's obviously a case where if you've got the injunction, that you have shown that a defamatory statement has been made. So it isn't really that doesn't really it's an example of a different scenario. The scenario that I'm contending for is insofar as the judge is essentially saying, well, if you can't get damages for the protected period of speech, it doesn't make sense that the protected period or whatever it may be, protected period of speech or writing. If you can't get damages for that period, it doesn't make sense for that period to be taken into account for the purposes of asking has the Section 1 threshold been crossed. And we say that that doesn't follow. Obviously, that is a submission that's rooted in my primary submission that it's a one-off test. So what I'm saying is, but insofar as the judge says, well, that's not satisfactory because of the issue of damages. In fact, the fact that you can't get damages for the the protected period. It shows why one doesn't need to construe Section 1 in this way to make sure that defences remain effective.
Well, I thought she was making a slightly different point here. It's very compressed, but there is something puzzling on the face of it if, let me just call them harmful and harmless.
Yes.
That's not what I really mean, but you understand the point.
I think so.
So the harmful publication, which is defensible, is the reason why damages can be recovered for the harmless publication. That doesn't make sense.
Well, it does because I mean, query can if it is harmless. Firstly, can damages be recovered? It doesn't follow that they will, or they could be derisory with the inevitable cost consequence. And it also doesn't stop the court saying, well, what is left after the establishment of the defence is so trivial. It's not a real or substantial tort, and it's abusive. And it can.
Well, let me then modify the example. No, because I was taking it to its extreme.
Yeah, I can see.
If we then modify it and say, well, the seriously harmful publication, which isn't actionable because it's defensible, is the reason why you get damages for the harm that is not serious. That's the puzzle.
Well, in my respectful submission,
that's what I take it to be saying.
Yes, I mean that is simply. I mean, we have a particular reform. As Lord Sumption says, it's not a particularly joined-up reform. Lord Sumption doesn't even think that Parliament's probably understood how it interacts with limitation. He says that in Le he says it's piecemeal and he's and such like. And the way that has been alighted upon to introduce this particular form, we say, is simply to introduce as a threshold test at the beginning as to has this caused real world harm in order to weed out the cases.
Well, the question is what this is.
Yes. Yeah, of course.
That really is the critical question.
But, I mean, what I'm proposing is that the mechanism that has been used, and perhaps it might be thought a crude mechanism, but Parliament has essentially introduced this threshold test at the outset. Is this a sufficiently? Has this caused serious real-world harm, or is it likely to? And if it is, you can proceed, and then you're at the mercy of defences if you happen to encounter them. But in our respectful submission, that is perfectly coherent and effective. And insofar as you subsequently meet a defence, as I've already suggested, well, it would be curious if because you've met a defence, you had to go back and ask all over again, has there been a tort? Because that's not the way defences usually operate. You don't restart. You don't restart the process. There is prima facie liability which the defence protects you against. You don't need to do that. And secondly, any anomaly of the sort which my lord has put to me will flow from the judge being able, in an appropriate case, to say, well, there is so little left, and once you're outside the protection of the defence, there is simply nothing which can be substantially compensated, or it's too de minimis to be allowed to proceed at all. But there may be other cases, and we would obviously suggest that this is one, where even if the judge is right in finding that there was not serious, there was not serious harm at any unprotected time, because the publication which has been seriously harmful is still out there. For example, the court at least has power to grant an injunction if that's appropriate. I mean, well, the consequences that the judges and my learned friends' analysis leads one to is whereas I described it, Mr. Banks finds himself at the beginning of my submissions. He finds himself with a publication, in the case of the TED Talk, that continues to be watched thousands of times. Which has caused him serious harm in the past, which the respondent accepts contains an allegation against him which is untrue, and yet has been left entirely without a remedy. Now, approaching Section 1 as we approach it doesn't require put the court in that highly polarised position. So long as you've got serious harm, you can proceed with the action, and essentially, if you thereafter encounter a defence, then that defence is considered on its merits, but you don't reset the Section 1 clock. That's my proposition.
Did you have you considered the implications of Section 8?
Yes.
4. And this is in relation to the question of fairness which you identify. What remedy might be open to imposition that you say arises in respect of Mr. Banks?
So I'm just going to section 8 is not in the bundle, so I'm just going to it.
I think it is.
Oh, is it?
It is, yeah.
Oh, forgive me, I forgot that. Sorry, I've been. Thank you. Well, I'll go back to the bundle in that case.
This deals with the imposition of as it were, a
single publication rule.
A single publication rule in respect of the claim at the outset and circumstances in which that can be abrogated.
Yes. Well, I mean, so far as we would in fact say that the learned judges it's actually the learned judges approach, which it risks introducing anomalies in the operation of Section 8. Because the way in which that is acting, let me just come to the note I had on that. So under Section 8, in respect of a continuing internet publication, you get your 1 year limitation period starts running as soon as the statement is first published. That's the effect of Section 8, altering the common law. Yet on the judge's approach, the temporary existence of a defence to initial publications means that serious harm is ignored during the currency of the defence. And so the statement is not defamatory even though time is running and may expire.
That problem wouldn't exist if the prospect of future publication at the time that the decision has to be made makes serious harm likely.
No, of course.
Again.
If you've got that, and of course, I mean, it is quite difficult to think of cases where, apart from maybe the particular rules around people trading for businesses trading for profit, but if you forget about those particular rules, it's probably quite different difficult in the case of private individuals to think of an instance where there won't at least be the likelihood of harm established really close to the moment of publication. But one suspects it might theoretically arise. If a statement is made to a very closed group of people and it subsequently unexpectedly emerges, one I suppose could posit examples which it might happen. But we still say that the way in which Section 8 essentially sort of fires the starting gun at the moment of the first publication, but on the judge's analysis, when you're asking yourself, am I going to cross Section 1, you also have to start thinking about not only am I suffering or likely to suffer serious damage, but am I also going to be able to defeat any defence? And you essentially have to do that in order to cross the bar. You could end up into a sort of Schrodinger's cat situation where you will simultaneously have a case which is where the tort is complete for the purposes of limitation, but isn't complete for the purposes of Section 1.
Yeah, well, that was the problem that Lord Sumption and I both grappled with.
Yes.
And so did the Court of Appeal. I mean, it's your coherence point again, I suppose.
Yes, indeed. And of course, what Lord Sumption, Lord Sumption's answer is in I mean, his first answer is Section 1 and Section 8 aren't, if they operate in tension, so be it. That's because Parliament probably hasn't thought about it properly. Very crude way of summarising it, but I don't think that's an unfair summary of what he says. Then his second point is really to say it's not a real world problem, because in the vast majority of cases, subsequent damage will simply be evidence of the damage which is suffered either at or very close to the point of publication. Sorry, I was dealing with the judge at 58. So I think the submission I've got as far as making the submission. This is also unnecessary because of the common ground that this is taken into account for damages purposes. As to the learned judge's reliance on what Lord Sumption says in paragraph 24 of Lachaise, which is quoted there, I mean, that is Lord Sumption addressing a very particular argument relating to the Dingle principle about disregarding damages caused by similar defamatory statements, and which Lord Sumption rejects, saying the Dingle principle is well established and it has the same practical advantages in the context of Section 1 as it has in a damages context. and it would be irrational to look at a related principle of causation in two different ways in close proximity, in circumstances when nobody was saying that Dingle should be abrogated. So it was a very, very particular scenario. We aren't here concerned with two competing theories of causation. We're simply concerned with whether when Section 1 is to be applied. And so in our respectful submission, what Lord Sumption has to say about Dingle is not in point. And nor does the Section 4 defence itself have anything to do with causation. A public interest, if a defendant has a public interest defence, it doesn't mean their statement hasn't caused harm. It means the defendant isn't liable for it. So what Lord Sumption has to say about causation in our respectful submission doesn't support the proposition being made by the judge.
Mr. Williams, I'm sorry to interrupt you.
Not at all.
You said something there very quickly, but it may
It's a fault of mine, I do apologise.
No, there's no need for apologies, but it may be at the heart of your submission on ground one, because as I understand it, but please correct me if I'm wrong, your fundamental submission under ground one is that the judge fell into error because she confused two different concepts. One, is there serious harm? Two, is there an actionable tort? Have I got that right?
Well, so, I mean, so obviously, serious harm is one of the ingredients of whether there is an actionable tort.
Of course.
But yes, but I'm saying that Section 1 is narrowly focused on an assessment of whether a given statement has a defamatory quality.
Sorry, forgive me. I think, is this right? Your fundamental submission is that the fact that you may have a defence to something which causes serious harm does not prevent it having serious harm.
Yeah, well, it's certainly...
They're two different questions.
They're two different questions. It means that you're not liable for the serious harm that you have caused.
That's why I said it's not an actionable tort because you're not liable. You're not liable because you've got a defence.
Yes.
But you say that doesn't alter the starting point, which is that there was serious harm.
Indeed. Yes. I'm grateful for...
I'm not saying that you're right.
No, I didn't think that you were.
But at least I understand what
I'm grateful for the elucidation, rather than have any presumptuous belief that your Lordship was agreeing with me. No, absolutely not. And just to conclude then on Lord Sumption, certainly in our submission, there can't be any suggestion that at paragraph is it 24 of Lachaud, he's making some general point that the threshold requirement of Section 1 has to be assimilated with the way in which damages are assessed or the way in which defences are assessed. There's no sort of suggestion of a universal assimilation. And in fact, that proposition would be completely impossible, I would respectfully submit, to find in the words of Section 1. And it would also be inconsistent with Lord Sumption's wry observation about the lack of connectedness in the way in which Parliament has been legislating in this area, even within the Act itself, between Section 1 and Section 8, thinks his Lordship. And then, of course, in that passage from Lord Sumption, he, again, is explicitly using, and I do take my lady's point that one mustn't get too sort of captured on particular words used in secondary sources or metaphors, but even there, Lord Sumption is using the terminology of threshold. So the final point made by the judge, this is paragraph 59, and we've to some extent anticipated this, is very prominent in my learned friend's skeleton arguments. It is the invocation of the Duke of Brunswick principle. Each communication of a statement constitutes a separate cause of action. Now, subject to Section 8, in respect of limitation in isolation, that principle survives. But in our submission, it isn't applicable to the interpretation of Section 1. Because Section 1 isn't derived in an assessment of individual publications, but on an assessment, and I know I've made this submission already, so it follows on from a debate we've already had, but it's an assessment of whether a particular statement is defamatory, and that is asked by examining whether or not you have serious harm, or its likelihood. And we respectfully say that simply can't be an exercise which is conducted distinctly in the case of each individual publication through some sort of importation of the Brunswick rule. It's focused on defamatory character and consequences, and far from mandating a separate assessment of serious harm in respect of each theoretically separate cause of action. The threshold issue is assessed with regard to the extent of publication overall. And certainly, whilst acknowledging that this nuance didn't need to be considered in Lachaud, and without asking your lordships and your ladyship to turn it up, it's paragraph 21 of that case, where Lord Sumption, if I may respectfully say so, resolutely approves my lord, as Mr Justice Warby's approach at first instance, demonstrating that Mr Justice Warby had considered issues like print runs, estimated readership, online user numbers, so as to base his finding of serious harm on the scale of publications. And that's what Lord Sumption describes it as, the scale of publications. So it is, certainly in that case and many others, a holistic exercise in which the overall consequences are considered in order to ascertain whether or not there is serious harm or its likelihood. And in our submission, therefore, Duke of Brunswick has no bearing on the operation of Section 1. Section 1 is mandating the threshold test of serious harm or its likelihood, which the court evaluates having regard inter alia to the extent of publication overall, but all the other circumstances, so that it determines once and for all, at the outset as a threshold question, the crucial question of whether the statement being complained of is in fact defamatory. And if it is, you cross the bar, raised as it is by Section 1 from its common law position, and if it isn't, you don't, and you never get to the question of whether or not there's a defence. So that is the grounds of our respectful disagreement with the learned judge. If I can just very briefly, or well, that may be an overpromise, briefly deal with the some of the points made against me in my learned friend's skeleton. And I'm going to turn up at paragraph 13 of their skeleton. So at 13a, they say that we've failed to grapple with the implications of our position, and they then say what they think they are. So at A, they say the common law principle that each publication of a defamatory statement constitutes a discrete tort has been abrogated, and through the 2013 Act, Parliament has provided that all libels arising from the publication of a statement should be treated as a single tort. In our respectful submission, that doesn't follow at all, really for the reason I've already given. Section 1 is not concerned with the rule about separate publications. It simply mandates, if we're right, a holistic assessment of the harm emanating from a statement in order to determine whether or not that statement is defamatory, such that the case crosses the bar. 13b, they develop that to say this single tort occurs at the date on which the claimant is first published to anyone other than the claimant. Respectfully, we say that's falsely premised. There is no radical change of underpinning theory, so there's now just a single tort. There is simply a different Section 1 exercise, which is introduced, or super-added, as I put it, to the common law, a single assessment of whether the given statement crosses the statutory threshold. At 13c, they say the court should rely on lawful non-tortious publications, which, if the case takes a long time to come to trial, could amount to years of lawful publication. We respectfully say that that is misdirected. Section 1 isn't concerned with whether a defendant is in fact liable. This is the point that Lord Justice Singh, my Lord Justice Singh, put to me a few moments ago. It's not concerned with, the question isn't is he liable, it's simply concerned with whether the statement is defamatory. And if it is defamatory, then the court goes on to consider whether the claim is otherwise made out, in which case liability may or may not founder, and if it does founder, may founder partially or absolutely on the existence of a defence. But that is not the Section 1 exercise. And at 13d, my learned friend says this reasoning applies not only to the public interest defence, but to any defence. And if I can be forgiven any apparent discourtesy to them, which I don't intend, I answer that with a crude "so what?" Yes, that is where our argument takes us to. But the same applies to any defence which may be raised. But that's because Section 1 relates to the anterior question which I have sought to identify as to whether or not the statement is defamatory, which doesn't involve any consideration of defences. And then at 13e, and to some extent this has been canvassed already, they say provided the serious harm condition has been satisfied The statement need only be published to one other person after the defence for a claim to be made out and relief to follow. And the answer to that is, well, perhaps. It depends on the circumstances. It may very well be relief doesn't follow because there may be an award of nominal or derisory damages or dismissal as a Jamal abuse. But it's simply not to the point. As I've said, as I've acknowledged, it might have been, Parliament might have structured matters differently or in a more thoroughgoing way. But in my respectful submission, the parliamentary intervention is in fact this, and as I said, if it is to be characterised as a crude intervention, then so be it. But its intervention is simply this one-off statutory bar, do you cross it or not? It perhaps also does worth saying with these points of these points made by my learned friends, and I hope it's not thought by them to be a cheap point, but insofar as they're now suggesting that Mr Banks's approach leads to catastrophe, it leads to abuse of Article 10 rights and such like, the approach we are contending for is the approach that they themselves were contending for until the moment the judge herself raised this point during my learned friends' closing submissions. In their skeleton argument, they specifically, their skeleton closing submissions, they actually say the consequence of the partial defence that they contend for would be essentially vanishingly small. There would be vanishingly small harm, and there should be essentially there should be no meaningful remedy. That's what they themselves contend for. I don't invite you to turn it up, but for your note, it's supplemental bundle, tab 6, page 233, and paragraph 135 of my learned friends' closing submissions. So in the proposition that there is a sort of let the heavens fall aspect to my submissions really is quite difficult to follow when one recalls that it was the position they themselves were advocating up to including their closing written submissions. Albeit, of course, there would have been a radical disagreement between Mr Banks and Ms Cadwalladr as to just how small the damages should be. Of course, that goes without saying. But the basic way in which the law operated was consensual until the judge herself raised this alternative analysis. As I've said already in our submission, it is in fact the respondents, I mean, insofar as this is a parade of prejudice, and I appreciate the court may think it's not helped by a parade of prejudice in any way, but insofar as it is a parade of prejudice, it's the consequences that result from the respondents' analysis, which we respectfully suggest are unwelcome. Because as we've said already, the fact that on their analysis, the unprotected period of the statement isn't even considered defamatory, despite having been found to cause serious harm, means that, for example, Mr Banks can't injunct the false statement that continues to be out there, published and misleading the public.
Just remind me, what role did the concept of likely harm play in the trial? In other words, of future publications and the likely harm that would.
Well,
and how did that intersect with the issue of relief, in particular an injunction?
The answer is that so far as the learned judge is concerned, we'll come to this in the PTA application. The learned judge finds the tweet doesn't cause serious harm at all, so no issue of serious harm there. And so far as the TED Talk is concerned, she finds the unprotected publication doesn't cause serious harm, and serious harm is not likely in the future.
No, I was asking what role it played at the trial.
Yes. Can I just see if I...
what she said in the judgment.
I realised as I was answering you that I thought I was possibly answering the wrong question. Can I just turn behind, not having had the advantage of hearing below? I mean, we with the caveat that neither of us appeared below, so I'll stand corrected by my learned friends who did. We don't believe that there was any distinction between actual harm and likelihood of future harm in the lower court, precisely, well, really for two reasons. Firstly, because this nuance introduced by the judge was not, as I've said, the way either party approached the question of serious harm. So no one pleaded or directed any evidence towards any attempt to chop up serious harm in a chronological manner. It simply wasn't an exercise that either party did, because neither party thought that they needed to. And secondly, on Mr. Banks's, on the traditional understanding that serious harm threshold was only crossed once, then at least in respect of the TED Talk, I know my learned friends didn't concede it, but I mean the approach on Mr. Banks's side was say, well, serious harm is so obvious when you look at the gravity of the allegation combined with the the scale of the publication. I think at the time of the trial, the TED Talk had been published about 4 million times. Again, there was really no need to focus separately on future harm. That is only a consequence of the judge essentially having introduced this chronological guillotine beyond which serious harm needs to be considered again.
I suppose if you had considered it, or if those who were there had considered it, they probably would have thought, well, if the harm is serious in the period in the second phase, if I can call it that, then there's a likelihood of further serious harm after that phase, as that phase continues after trial. And the converse would also be true unless there was some reason to think otherwise.
Yes, I think that the short answer to my lady's question is that given the forensic shape of the case and as it stood at the trial, there simply wasn't a need to make a fine distinction between accrued harm and likely future harm. When my learned friends say at 13E, provided the serious harm condition has been satisfied in respect of original publication, you can still get relief. So I said already, well, actually by no means necessarily can you get relief. But in our respectful submission, in appropriate cases, you should be able to get relief, because Mr. Banks's conundrum really is a case in point. He's unable to restrain repetition via an injunction, or to get any sort of, even if it's a relatively, and I don't for a moment concede that it would be, but a relatively token of public vindication by way of damages, in circumstances where the false statement is still out there, and the respondent, who is culpable, at least in the broad sense, for making, if not in the legal sense on the judge's findings, for making grave but false statements, has got absolutely no incentive economically to assist in preventing repetition. And on the contrary, and as I've said, she has continued to call attention to the TED Talk, making no public acknowledgement that her allegation about Mr. Banks and Russian money is false. And as we've now seen, doubled down on that in the last 12 hours in the tweet that I mentioned in opening. Just to finish my run through my learned friend's skeleton, they also say at paragraph 20, it's an elementary principle of tort, there's no liability in the event of the defence. Well, that of course is right, but that again we say confuses liability in toto with the section 1 question of the antecedent requirement of building the torts, showing the defamatory statement. And also it doesn't follow from that obvious principle that the claimant has to demonstrate there is no defence and prove the tort all over again as a result of the intervention of section 1. In our respectful submission, it is simply a non sequitur. And then there's an extensive reference from paragraph 23 onwards to Article 10. They say at paragraph 23 that it follows from Mr. Banks's case that lawful publication forms the basis for defamatory liability. But it doesn't, because there's no liability for lawful publication because of the defence. The defendant only remains liable for publication which is not protected, with the added benefit that section 1 has already protected it from being pursued for non-serious statements, or statements which have caused none serious reputational harm. So there can only be a liability if a statement that has caused serious harm, or is likely to do so, is repeated after the expiry of the defence. And the putative defendant remains in a better position than they were before section 1 was enacted. And since there's nothing to suggest in anything from Strasbourg or from a domestic court that our law was not Article 10 uncompliant before section 1, one doesn't understand how section 1, the interpretation of section 1 could somehow now make it Article 10 uncompliant now. At paragraph 24, we also, if I can respectfully say so, have a certain sleight of hand in eliding the respondent's scandalous and false comments about Mr. Banks and Russian money with the Facebook talk as a whole, and where they say the starkness of the position is demonstrated by the facts of this case. At the risk of making a jury point, well, we say, yes, we agree, starkness is illustrated by the facts of this case, but what is stark is the position that Mr. Banks finds himself in the face of a grave allegation which the respondent has accepted was false. In our submission, our law is perfectly compliant with Article 10 because the respondent has the benefit of statutory and common law defences together with the raised statutory bar which results from section 1. And if that bar is crossed, and defamation continues once the defence lapses, then there can be no issue with liability after that date, offending Article 10. And obviously, it goes without saying, though in the traditional way I'm going to say it, that Mr. Banks has his own convention rights in any event under Article 8. And as I've said, if anyone has a cause for a rights-based grievance, it might be thought to be Mr. Banks and not Ms. Cadwalladr. The last points I wanted to make, and I appreciate that these are sort of very incidental points, but we say they're not to be entirely ignored, is looking at how matters work practically. And that isn't just an appeal to the jury, because one can assume that Parliament is not going to want to have crafted a scheme which would be difficult to implement in practice. We do say that it is, notwithstanding that this is very much belittled in my learned friend's skeleton, we do say it's very difficult for a claimant to break down serious harm chronologically, segregating harm into different periods, and working out when particular people saw a particular publication. And we address this in some detail at paragraph 20 of our skeleton. It leaves claimants not knowing what they need to establish to satisfy the serious harm test and when, and potentially needing to get together evidence, which is all the case law recognises is difficult evidence to harvest, even on a holistic basis, but to harvest such evidence with reference to one or more chronological points. And in some cases, of course, as this was one, there's a multiplicity of candidates for potential chronological points at which a defence might lapse. And this is, and as I've said, in this case, neither party in their pleadings or their evidence made any confrontation with those difficulties because they simply didn't realise that they existed. But it's perhaps worthwhile that Lord Sumption himself in the show, approving the holistic exercise performed by my Lord at first instance, he specifically comments, it's paragraph 21, that precision will rarely be possible. And yet, in our submission, what the respondent calls down is a need for precision in a world where, indeed, as the judge herself acknowledges, when she says, she essentially says, I'm not surprised Mr. Banks is relying on inference, because he's not going to be able to get members of the public to come and give evidence about, I now think the less of him. Well, how much more difficult to say, I now think the less of him, and it's because of what I read after a particular date. So it does give rise to practical problems. And we also say the respondent's argument actively encourages any defendant with a potential defence to deny serious harm, even when it might be thought obvious that serious harm has been suffered, in the hope that if a defence is established for at least an initial period, the claimant will struggle thereafter to prove further chronologically specific ex post unprotected serious harm. And so it's likely to lead to more contests, it's certainly in cases where there is the possibility of a partial rather than absolute defence. And we've already averted to possible issues in respect of limitation or confusions. So in summary, on the point of law for which there is permission, we submit the learned judge's approach was wrong if she fails to apply the section as it should be applied as part of the test of whether the statement is defamatory, dependent on actual or likely consequences, with no requirement for potential defences to be brought into the account. And any concerns as to trivial, indefensible publications can be dealt with, and are much better dealt with at the remedies stage. Now, if I can then move on to the permission to appeal applications. The respondent skeleton puts great emphasis on the principles of appellate restraint which apply in this area, and we immediately acknowledge those principles. I have to demonstrate some material error in the judge's reasoning, or else an outcome which is outside the range of reasonable decision making, even allowing for the wide ambit within which different judges can reasonably disagree. So I entirely accept that that is the gradient up which I must trudge. But with respect to the judge, we submit that in the present case both limbs are satisfied, errors of reasoning and indefensible outcome, and in respect of both the tweet and the TED talk. Now, so far as the legal background is concerned to this part of the case, it's usefully summarised by the learned judge herself in section E of her judgment. And I was going to take it up, if I may, at paragraph 51. And and I was going to refer within paragraph 51 to starting at Roman 7, which is page 74 of the bundle. So at Roman 7, she says, a claimant who has the burden of proving that a statement caused or is likely to cause serious harm to his reputation may do so by evidence directly going to prove such harm or by inference from other facts. A claimant may produce evidence from those who watched, heard or read the statement complained of about its impact on him, but his case will not necessarily fail for want of such evidence or miss out the internal citations. The difficulties of obtaining such evidence from those in whose eyes the claimant's reputation was damaged are obvious and well recognised, the point I made a few moments ago. Comments posted online by those who have watched, heard or read the publication can be evidence of reputational harm to the extent they can be said to be a natural and probable consequence of the publication complained of. And there's a citation of my lord. Sometimes inference may be enough, but it cannot always be. The evidence may or may not justify an inference of serious harm. Inference is a fact, just the serious harm done to a claimant's reputation may be drawn from the evidence of the whole, including the meaning of the words, the scale and the circumstances of the publication, the claimant's situation and the inherent probabilities. Skipping the in citations, even a seriously harmful allegation against a person may not cause serious harm to their reputation if those within the jurisdiction to whom it has been made consist only of people whose opinion to the claimant is of no consequence to the claimant. That is the one area where I may differ from the judge, and I'll come back to that. And all those who are unlikely to believe the words, citing again my lord. And then jumping down to the foot of the page of Roman 12, in general, a libel has a greater potential to cause harm if it's published to the world at large, and if it has been published repeatedly than if it's been published to a single person on a single occasion. But assessment of harm to reputation is not a numbers game. And then a vivid quotation from my lady: one well-directed arrow may hit the bullseye of reputation and cause more damage than indiscriminate firing. Very serious harm to reputation can be caused by publication to a relatively small number of publishees. Moreover, in an appropriate case, the claimant can also rely on the likely percolation or grapevine effect of defamatory publications, which has been immeasurably enhanced by social media. So, subject to the one point I reserve my position on, those are the some of the key principles. I know that to at least two members of the court they're extremely familiar, and I apologise if I have laboured that more than I needed to. I think that, however, it's probably also worth also turning up Monroe and Hopkins, which is tab 6 of the authority bundle, and I'm going to paragraph 69. So it's tab 6, paragraph 69, and it's page 137 within the PDF. So Monroe and Hopkins is the case where there were tweets asserting that Jack Monroe, the writer, approved of, amongst other things, vandalisation of war memorials. And I think, from memory, the extent of the publication, it's just interesting sometimes to have these points in mind as one goes through it. I think the extent of the publication in Monroe, there was one tweet which my lord found to be the more serious one, which was published to about 20,000 people. And there was a second tweet, in respect of which my lord allowed a smaller sum of damages, which was published to about 100,000 people. So that's the background to Monroe. And I was on paragraph 69. My lord says an allegation, where an allegation has a serious defamatory tendency and is widely publicised, a claimant may choose to rely on those facts alone, perhaps in conjunction with evidence as to the identity of the publishees, on the basis for an inference that serious harm was actually caused. So that's actually a passage that I've shown you before. But my lord acknowledges there that one can, in these circumstances, rely on inference, and that's a point that's made a number of times in the authorities because of the evidential difficulties. Now, before coming to the 2 points on which permission to appeal is sought, the judge's analysis needs, we submit, to be read in light of her antecedent findings in respect of the TED Talk for the initial protected period of publication, because she really refers back to her earlier findings when dealing with the other two themes. Now, so far as this is concerned, it's in her judgment at paragraph 86.
Have you finished with Monroe?
I'm going to come back to it.
But not right away.
Yes, and yes. Sorry, if you'd like me to, well, you've shut the folder now. Yes, so I was going to show you paragraph 86 of the judgment, which is page 84 of the bundle.
Yeah.
So, in respect to the TED Talk, for the protected period, she finds serious harm, notwithstanding that it's an inference-based case. So 86, there is no evidence from any person to the effect they saw the TED Talk, and their opinion of Mr. Banks was lowered as a result. The absence of such evidence is unsurprising. Anyone who thinks poorly of Mr. Banks would hardly be likely to put themselves forward to support his case against Miss Cadwalladr. On balance, I'm persuaded that it can be inferred that a sizable number of people who knew or would later come to know Mr. Banks would have viewed the TED Talk and believe what was said about him, lowering his reputation in their eyes. I consider that this is a proper inference to draw given the extent of publication, the gravity of the single meeting, the serious nature of the TED Talk, and the fact that it was given by an award-winning investigative journalist, and the authoritative and credible nature of the international platform on which it is given, that is, at the main TED conference. And she also, and this is a point that does become personal because it's part of our case that really my learned friends are trying to reintroduce it by the back door. Between paragraphs 87 and 89, she rejects a case of pre-existing bad reputation in respect of Mr. Banks. And can I just invite the court to cast an eye over paragraph 87 through to 90? Thank you. So that's so as I say, those findings in respect to the protected period of publication are relevant to the areas in which PTA is sought. So if I can come firstly to the tweet, because that's the sequence in which it's addressed in the grounds of appeal and in the judgment. The judge's finding, of course, was that serious harm in respect of the tweet was never demonstrated. And we are driven to say, for the purposes of this application, that she came to that conclusion because she made mistakes in reasoning. But in any event, it is simply not a defensible conclusion to which to come. And to start to make what I appreciate is a high submission good, if I can begin with the figures which the judge sets out at paragraph 67, which is at page 78 of the bundle. And there needs to be a correction here because the judge has, doesn't pick up on the judge has accidentally given the date of the tweet itself. What the judge is referring to in the first part of this paragraph is to the position as it was on the 31st of July 2019. So that's 5 weeks after the tweet. And the significance of that date is it's the date of service. So that's why those figures are significant. That's why those figures have been crystallised. The figures as crystallised at the date of service.
Sorry, what date do we need to correct?
The date that says the 24th of June 2019, my lord, should be, that's the date of the tweet, should be the 31st of July 2019, which is the date of service. So as of that date, the tweet had appeared in the timeline of Ms. Cadwalladr's 311,000 followers, and then been retweeted 8,915 times, consequently appearing in the timelines of any other followers of those accounts, and had been liked over 20,000 times. And then there's a reference to slightly different figures in Mr. Banks's witness statements. Don't need, just for those, I suspect that members of the court understand how Twitter operates, but essentially the reason the figures change somewhat is that as people leave Twitter, their likes and retweets are subtracted from the totals. And so some of the accounts which retweeted Ms. Cadwalladr may have ceased to exist or been shut down or something of that sort by the time Mr. Banks gave his number. But it doesn't really matter because on any view in our submission, this is a mass publication. And to make that good, as we say in our skeleton, if one just looks at you begin with her followers. There are over 300,000 of them, and she's a mass followed journalist, and she's rightly in her pleadings, stresses her credentials as a journalist. She's a serious journalist writing for respected publications, predominantly The Guardian and The Observer, and she was in 2018 the winner of the Orwell Prize. So she's a serious journalist, or apparently so, with a serious platform in The Observer and The Guardian predominantly. And so therefore she has over 300,000 followers of her own, all of whom will have had the tweet come into their timeline. So we can't, of course, prove if they actually read it, but many of them, very many of them, are going to have done so. Which is something itself is illustrated by the fact that there were thousands of retweets and likes. And the consequence of the retweet is that it's therefore propelled by the retweeter to all of their own followers. And as we say in our skeleton, if you just assumed that they had 100 followers each, the retweets massively overtake Ms Cadwalladra's own tweets, because that would be another 900,000 people. And of course, if even that might be a substantial estimate, if any of the retweeters were themselves people with an amassed following, but there wasn't any evidence about that. But we say even before one allows for onward percolation, immeasurably enhanced by social media, in the words of the authorities, which the judge herself cited. And the fact also the tweets will be turned up for people that don't use Twitter at all by, for example, Google searches. This was a very large-scale publication. Now, in Riley and Murray, for example, that's one of the cases in the bundle, the case resulting from the tweets that related to an egg being thrown at Jeremy Corbyn and Ms Riley's subsequent reaction to that. And Mr Justice Nicklin, in that case, estimated readership at 10 to 15,000, which he described as equivalent to the print edition of a regional newspaper. I won't ask you to turn it up, but for your note, that's paragraph 140 of Riley and Murray, which is tab 12 of the authorities, paragraph 140. And then in Monroe and Hopkins, my lord found that one tweet, as I've said already, was viewed by about 20,000 people, and another by about 100,000 people. And in both those cases, serious harm was found on the basis of scale of publication. But in both those cases, certainly it would be our submission that the scale of publication was joined to a tweet whose defamatory implications were far less grave than the tweet in the Pleasant case. It was obviously most unpleasant for Jack Monroe, as coming from a services family, to be depicted as somebody who is delighted by the desecration of war memorials, and for Miss Murray to be accused of irresponsibly encouraging people in their reactions to Jeremy Corbyn. And not suggesting either of those are de minimis torts. Of course, if they would have been, they wouldn't have crossed a serious harm threshold. But to compare them to being portrayed to a mass publication as the cat's paw of the Putin regime, acting dishonestly, and far from your position in the Brexit debate, merely being motivated by. I'm muddling my words slightly. Your position in the Brexit debate being affected by the fact of funds being received from a foreign regime, and particularly that foreign regime. In our respectful submission, I mean, that is a gravity which is of a different order of magnitude. And yet, as we've seen to the tweet, on the face of it, to a much, much larger group of publishees.
But Mr Williams, I think you accept, don't you, that it's not a numbers game?
No. But the irony is, however, is that phrase is almost always used in cases where the number of publishees is very small. That is the native habitat.
Yeah, the converse must be true as a matter of principle, that you could have wide-scale publication that doesn't actually cross the threshold. That was one of the propositions in Ames. It wasn't made out, but it was. Yes. Well, there were reasons for it. Yes. That were specific to that case.
Well, and if one thinks, for example, the common law test of amongst other things, holding a claimant up to ridicule. Now, one can ask, you might have a very widespread tweet which merely held someone up to ridicule, and it may very well be that in a post-Section 1 world, even very widespread ridicule doesn't amount to serious harm. It might do, but you can see it might not.
It's questionable whether it even counts for the purpose of Section 1 as harm to reputation.
Well, indeed, exactly. There is that, precisely so. So, my lord, you're absolutely right. It's not a numbers game, but in our, and that's why I was stressing one has to yoke the numbers to the statement.
I completely understand that, but doesn't this come up against your fundamental difficulty in running this ground, which is that we're not the tribunal of fact. Inevitably, we can only be shown part of the evidence. We don't have a feel for the entirety of the evidence, including oral evidence that the judge had.
Yes. Well, I mean, certainly, as I have acknowledged, I recognise the principle of appellate restraint, and so certainly your lordship would think extremely long and hard before substituting your judgment for the judgment of a trial judge, unless they've made a vitiating error of reasoning, which I'm going to come on to. Yes. But obviously, ultimately, this court can and does interfere with outcomes which are plainly wrong. And when, for example, you have a case like Riley, and there must be some consistency in the law. Of course, different judges sitting in neighbouring courts can come within a margin of appreciation to views which don't measure up precisely. But when you do have, in a case like Riley and Murray, a publication that's to only 10 to 15,000 people, suggesting that you go around encouraging people to throw eggs at Jeremy Corbyn, and combine that to a publication to hundreds of thousands of people, saying that you're the corrupt stooge of Vladimir Putin, if I can put it slightly crudely. In our respectful submission, and that is, one does have to ask oneself, is that within the range of reasonable disagreement? We're going to come to see momentarily that when you compare this decision to a subsequent decision by the judge herself, where a publication to what clearly was an echo chamber, because it was subscribers to a sort of newsletter or blog, which was overwhelmingly directed at supporters of Jeremy Corbyn, published to just 50,000 people. That's found nevertheless to cross the threshold of serious harm on the basis of the
scale of publication. I think you've taken us to the authorities on its relevance for the purposes of serious harm.
Yes. Yes.
And that you referred to the judgment of non-assumption in the show, and what my lord said in Le Show at first instance and other cases. Yes.
Yeah, and as I say, it is, and as to use the verb I used to my lord a few minutes ago, my Lord Justice Singh, it is obviously, I don't go as far as my learned friends attempt to impute to me of saying there is a rebuttable presumption, but it's the yoking of serious harm to an allegation of this character. And I certainly do say that when you compare this case side by side with all the other cases in the bundle, this case, if you'll forgive the cliche, it sticks out like a sore thumb. Because this is a case that involves what the judge herself characterises as a grave allegation, which in my respectful submission clearly is a very grave allegation against a person in public life. And it is yoked to a publication on an extremely large scale. And what really one does have to ask oneself is before I get to errors of reasoning, has this judge come to a decision which is so out of kilter with all of the others, is so inimical to predictability and coherence in the law, and putative claimants and putative defendants, being able to make judgments about the respective merits of their positions, that it does fall within that small rump of cases which it may fall to this court to correct. And notwithstanding the point which my Lord Justice Singh put to me, I'm afraid I do say that if I don't persuade you on errors of reasoning, I do say that is this case. Reasons I've now mostly anticipated, but I may just add a few more a little bit later in my submission, if I may. A particular point, and I know I said this at the outset, but I do in this context want to stress, because I do say the learned judge quibbled over the adverb extremely grave, but she accepted it's a grave allegation. And even if you accept the quibble over the adverb, I've said to them, this is to link somebody to the current Russian regime, post, for example, the events in Salisbury, is a very wounding, a potentially very wounding blow. I'm not suggesting, of course, it matters. It's about his reputation, not whether he was wounded. I accept that. I characterise it in that way. And one point which I do say that the learned judge, it's far from clear that she did appreciate or accept, is that even if one grants, come 2019, because of the Brexit referendum and his activities within it, there were lots of people in this jurisdiction with a low opinion of Mr. Banks because they oppose leaving the European Union. To suggest that he's in a secret and corrupt regime with Putin, the Putin regime, is of an altogether different character and magnitude from thinking little of his politics. For example, an ardent Remainer might very well have seen Mr. Banks as a deeply misguided, but at least basically patriotic person who wanted what he wrongly thought was best for the country. And that is quite different from alleging collusions with the Russians, which tends to suggest that you're anything but a patriot. And all of this in respect of what we call in our skeleton the paramount issue of the day. And he did this covertly and dishonestly. In this respect, I was going to go back, if I might, to Munro and Hopkins. And what my lord says in the case. But I'm afraid because of the latest security protocols, I have to insert a fiendishly long password every 15 minutes, and there is no way of turning it off. So I do apologise for these occasional longueurs. I'm even beginning to worry that whether I would now have to change it in case it could be seen on the live stream as I enter it. Monroe is paragraph 71, page 138 of the PDF. And I was going to... yes, it is subparagraph 7. Yeah, it's subparagraph 7 and 8, which are sidelined. Can I perhaps invite the court to look at those two paragraphs rather than me read them aloud? This passage I'm going to submit is relevant in two respects. Firstly, to the sort of point I've just been addressing, but secondly also to what the learned judge comes on to say about the echo chamber, which I'll come on to shortly. And particularly invite the court's notice to the way in which my lord dealt with that in this case. And as I say, I'll come back to that when I get to the echo chamber. Can I also, whilst I'm in the authorities, just briefly show you two other cases. The first is Turley, which is tab 9. I'm going to ask you to look at paragraph 114, which is at page 241 of the PDF.
Sorry, paragraph 1.
Forgive me, my lord. It's 114.
114, yes.
On paragraph 241.
Yep.
Again, it's sidelined. It's just the learned judge in that case making points about the perils of assuming typical readerships. And so I'm looking, for example, at the sidelined Roman 3. This is Mr. Justice Nicklin. He doesn't accept the submission that typical readership of Squawk Box, thank you, makes it less likely that serious harm has been caused to reputation. There's a danger of generalising, but even if there's a typical reader who has some pre-existing hostility to the claimant, either because she campaigned against Mr. Corbyn or because she was perceived by such readers being on the right wing of the Labour Party, this cannot lead to the conclusion that such a reader would discount what they read about the claimant in the article. On the contrary, any readers who already had a negative view of the claimant were likely to have that reinforced by allegations in the article. Indeed, there's evidence that at least one political opponent did so. So that's that case, and that's really the point. That really is the point I've just made. That even if one grants, as one has to, that an awful lot of it cross-fertilizes with the echo chamber point. Even if one accepts that an awful lot of Ms Cadwalladra's followers might have had a low opinion of Mr Banks already because of his position on Brexit, it's a very far cry from that to suggest that therefore one can discount this different allegation which she makes against him in the publications which are being complained of. which relates to something, as I've suggested, really quite grave. And the last case I was going to show you in this section is the judge's own subsequent decision in Warby and Sivier, which is the last case in the bundle, tab 14. And I was going to go to paragraph 114 of it, which is at page 462 of the bundle. And can I ask the court to look at paragraphs 114 and 115? Obviously, some of it can be skipped because it quotes my lord in the passage that we've read. And I appreciate, I don't want to be thought I'm making some sort of cheap jury point about the judge sort of seemingly contradicting herself. But when I do have to deal with potentially have to deal with the point that my Lord Justice Singh put to me specifically, how can we say that this judge was plainly wrong? I do say a compare and contrast of this subsequent decision and the decision she's made in the case of Mr. Banks really is extremely stark, because this is a case involving a much smaller publication. The judge makes a finding 50,000 people. It's a much stronger case for an echo chamber, because this is a sort of a cohort of people who, as she explains, are following a website which is strongly left-wing and vociferously supportive of Jeremy Corbyn. And it contains allegations which, although, as I have suggested earlier, are not to be brushed away, and allegations that she has. Ms. Riley has encouraged abuse and to put it in the vernacular, a Twitter pylon of somebody who's just 16 years old. We would say that is nonetheless an allegation of far less gravity than that made against Mr. Banks. But in that case, the judge has no hesitation in brushing aside an argument about the echo chamber and drawing an inference of serious harm for a smaller publication of a less grave statement. And in our respectful submission, I'm slightly getting ahead of myself, but because of Lord Justice Singh put that to me, we do say this is a troubling contrast, which underpins me having the temerity to say that this ultimately, if necessary, is a case where your ladyship and your lordships would find the judge has gone plainly wrong. So if I can finally come to the judge's treatment of the tweet in this case, which is very short. It's paragraph 91.
Just before you do, Mr. Williams, do you mind if we just remind ourselves of the terms of the single meaning that Mr. Justice Steyn determined this had, which is at paragraph 6.
Yes, indeed.
Of the judgment, because that may be of some importance, just to see all the elements of that.
Yes. So as your lordship, it's page 64. So it's on more than one occasion, Mr. Banks told untruths. And an allegation that untruths didn't mean lies was rejected. So essentially told lies about a secret relationship he had with the Russian government in relation to acceptance of foreign funding of electoral campaigns in breach of the law on such funding.
Yes. Well, that last clause in particular may be said to be of some importance.
Well, and that's why
it's not just a bad thing, but it's in breach of the law.
It's in breach of the law. And as I say, and it is, and in my submission, and I know I've made this point already, it's particularly important when one has in mind that the judge has rejected any case of there being general bad reputation. But she does say, well, lots of people, particularly the sort of people that follow Cadwalladr, might not think much of Mr. Banks already. But there's quite different for not thinking very much of him because you don't like his position on Brexit, than thinking he is a liar who's had a secret relationship with all people in the Russian governments, and he's done so not as a good faith actor in the debate about Brexit, however much I might disagree with him, but as a bad faith actor because it's about the foreign funding of electoral campaigns in breach of the law. So in my submission, that is a very, though the judge quibbles, or cavils, I meant to say, extremely grave, nevertheless, it's a serious allegation, certainly more serious, as I've suggested already, than some of those, such as in the Monroe case, the Murray case, and now the Sivier case that I was just looking at. So still within the judgment, if I can invite the court to go back to the tweet, which is dealt with between paragraphs 91 and 94. She begins in 91 by rightly reminding herself that in relation to the tweet, most of the matters are referred to as the same. The gravity is the same. Because the single meaning is the same. The lack of direct evidence is the same. But there are two crucial differences. And the first she identifies at paragraph 92 is the extent of publication. But all she does is she focuses on the extent of publication relative to the text. She says, firstly, though it's reasonable to infer most of her 311,000 followers on Twitter, and most of the followers of those who retweeted were within the jurisdiction. Nonetheless, the number of people within this jurisdiction to whom the tweet was published is likely only to be a fraction of the number who viewed the TED talk. The normal inference in the absence of reason to think otherwise would be actually a tweet will peak at the beginning, if I can paraphrase. And here she says there's no probability of future harm. But I mean, in my respectful submission, I mean that is an error of principle. It's not a numbers game in a different sense. It's not a numbers game to have a relative weighing up of TED versus tweet. What one has to ask is the extent of publication of the tweet itself is it an important factor in the holistic question of whether there has been serious harm? And in circumstances, as when I've said, where when one takes retweets into account, the potential audience of this tweet is on any view in the hundreds of thousands.
What I had read her in this passage to be saying, in summary, this: I've arrived at a figure for the TED Talk, and the figure that I arrive at for the tweet is a fraction of that figure. So it's not just a relative thing. She starts with a sort of absolute, and it's to be found in paragraph 81, accepting Mr. McCormick's submission that there was substantial publication at least equivalent to a high circulation domestic newspaper.
Yes.
Now, whatever that number is,
well, of course,
and whatever her fraction is.
Well, I was going to say, that what's the fraction?
Well, I think implicitly, it's a small.
I agree that it must be implicitly a small fraction. But in circumstances where the viewers of the TED Talk, let me not just dream up figures, but actually give them precisely. I mean, as of the end of 2021, you're in excess of 5 million. I mean, so even 10% is 500,000, and even 1% is 50,000. And yes, my learned friend makes the fair point that some of the TED viewers would be outside the jurisdiction. Yeah. Not so much with the tweet, but nevertheless, one is still talking about very large numbers of publishees, and the judge, the reasoning is porous, that. As I've said already, 10 to 15,000 people identified by Mr. Justice Nicklip as the readership of a regional newspaper, of the print edition of a regional newspaper. On any view, we're looking at a promulgation which appears to be very significantly larger than that. And certainly there isn't any sort of analysis of, well, 311,000 followers plus the retweeters. On any view, it is a publication of considerable scale. It might be a smaller scale than the TED Talk, but in my respectful submission, it is still a mass publication. Now, the second point is then the echo chamber point.
Before you leave the first of those points, I wasn't sure I understood the point in the last sentence of paragraph 92, which seems to draw a distinction between the future and the past. And the only question posed by the judge is whether it has caused serious harm. In her conclusion, in paragraph 94, she in fact did use in parentheses in line 5, or is likely to cause. It may be that I've misunderstood the terms of the judgment. Can you help me?
Well, my assumption is what the learned judge is talking about at the end of 92 is that because of the relatively ephemeral nature of the tweet, is that if and of course earlier in that same passage she's talking about it peaking shortly after its promulgation. So in essence, well, if you don't get over the has caused threshold, you're not going to get over the future threshold. I think it's probably.
And do you accept that part of the reasoning? Because I had in mind what you said a few minutes ago to us, that you don't even have to have a Twitter account to see tweets from the past, because, for example, if you Google, sometimes it'll throw up
Oh, it will, absolutely.
a past tweet.
Yes.
But do you accept her reasoning?
Well, I accept. I mean, unless I'm correct and behind, I accept the proposition that if 300,000 plus followers and 9,000 retweets, doesn't persuade a judge that you have suffered serious harm. You're very unlikely to show that the possibility of a future Google search, generally is going to be on a much smaller scale, is going to get you over a threshold you've otherwise fallen at. Excuse me. Yes, I mean, my learned friend Mr. Munden is reminding me that because of the changes that have recently been made to Twitter, one has now got much better insight into how often tweets are viewed, and the figures are really quite startling. As I said to you at the outset of my submissions this morning, the tweet that Ms. Cadwalladr made about this case last night, within 12 hours, 224,000 viewings. I think she has somewhat more followers now than she did in 2019, but she still, as we've seen, had an awful lot of followers back then. I was coming on to the echo chamber. I'm also conscious that I promised my learned friend I'd aim to finish by 12:45. So
before you do finish, we're going to ask both you and Mr. Miller to deal with the question of the consequences of the claim that you make in relation to your different grounds, because one of the issues that you raise, and I mention it because it's in the notice of appeal, is that you say, depending on the decision that we come to, that you invite us to assess damages, and that's not addressed in any of the skeleton arguments that we've seen by either side.
I think come our skeleton, we invited instead a remission, but I'll be reminded about that. And obviously your ladyship's quite right, of course we must indicate what we say the consequences of the appeal being allowed.
Well, we'd be grateful if there could be clarity as to
Yes. Yes.
I mean, speaking for myself, just following on from my lady, I perhaps incorrectly had understood you that if you succeeded on either ground 2 or ground 3 in establishing that there was only one answer which was available to the judge, in other words, you're plainly wrong point.
Yes.
Well, then if that succeeded, and I'm not saying that it will, but if it did, then I understood you to be saying that we should not be remitting because we should make that finding ourselves. Is that wrong? Forgive me. I'm trying to remember how we put it in our skeleton. I think it may have been that we merely said the assessment of damages should be remitted, not the actual.
Well, either way, we need clarity.
Of course, you need clarity.
And then we would need to hear what Mr. Miller has to say about.
Well, is that perhaps something that I can address you upon after the short adjournment? So I have the opportunity just to make sure I've got that right with my striking solicitor, with my learned junior. Thank you. I was just coming on to the echo chamber. Well, actually, just before I do, yes, just to finish on the extent of publication. We've already seen the judge's self-directions at paragraph 51, where she says a libel has a greater potential to cause harm if it's published to the world at large. Well, the tweet essentially is given the number of followers and retweeters and the fact it's accessible on Google, and it's been published repeatedly, which was another point which the judge identified as being material. And here we have the 8,915 retweets, each potentially seen by hundreds of further people per retweet, so a potential audience of hundreds of thousands on a conservative reckoning, none of which the judge mentions in this part of the judgment. And as I said, even if the viewership was only a fraction of the TED Talk, you're still looking at, for example, a much higher, a small fraction, say it's 2 or 3%. You're still looking at a much higher number of people than the judge found was the publishees in the Rachel Riley case she decided subsequently, where she found the readership was 50,000. and that yoked to a less serious libel was held to be sufficient, notwithstanding it really was made to an echo chamber. Now, so far as the echo chamber is concerned, the proposition that Ms Cadwalladr only tweets to her echo chamber didn't form part of her evidence or her defence. It's a surprising proposition to be made to an Orwell Prize-winning journalist associated with serious publications, who might be followed by anybody with an interest in public affairs, and whose oeuvre is by no means confined to Brexit. And to take an obvious example, Mr Banks follows her himself. And it's perfectly clear that many people followed her who do disagree with her, because if one actually looks through the tweet, which is in volume 3 of the bundle, I'm not suggesting we turn it up now, we give references in our skeleton. Obviously, there are lots of responses praising Ms Cadwalladr and damning Mr Banks, but there are also plenty of people joining in the rancour, making disobliging remarks about Ms Cadwalladr and her journalistic standards as well. So insofar as there was evidence before the court, it certainly wasn't evidence that she was broadcasting to a choir that was capable only of singing in unison. And all of the authorities, say Vardy and Rooney is an example of the danger of making assumptions about readership profiles, even in the case of traditional publications like the Daily Mirror that do have a pretty settled demographic. And in our submission, and we do say this in our skeleton, my learned friends dismiss it, we do say it's not an exaggeration to say that the approach the judge took in this case, and very starkly didn't take in the Sivier case, it would have serious consequences for public discourse in this country if you can simply assume that the opposing sides of a polarised debate can't do one another serious harm because they're only talking to people who are like-minded, even when you're talking about numbers on this scale. And then we also do say, with respect, that's in striking contrast to the approach of my lord, Mr Justice Warby, as he was in the Monroe case. And in that case is the quotation we visited just now, so I won't go back to it. Mr Justice Warby refers to his own previous decision in Barron. And that was another pure echo chamber case, as my lord may recall, because it concerned a statement that was made to a UKIP conference. But even there,
well, I wonder about that, because I've wondered about what the judge meant by echo chamber, because an echo is the same thing coming back at you. So it's not really the same as your point about a specific allegation contrasted with a general political hostility. If a true echo chamber, if I understand the notion correctly, and it's not defined in the judgment, would be one where I think that the proposition would be there was no harm because the people who heard what she said already held that view.
They already held that
getting
view.
Their own views played back to them.
Indeed.
So that's a slightly different point. And it might be, in theory, possible to sustain that by saying, well, look at all the other times that people had said the same thing, or that this defendant had said the same thing, and evidence that people in the Twitter sphere who followed this defendant held that view. But some of that seems to be ruled out by Dingle.
Some is ruled out by Dingle, some is ruled out by the learned judge's rejection of the general bad character evidence, which I've already shown you.
Yeah.
And as it's an obvious one, the judge doesn't even mention retweeters. And how does retweeting reconcile with the echo chamber, even if one accepted that this prominent journalist whose writings were of interest to anybody, I would submit, with a view on Brexit, whether they were leavers or remainers, let alone her wider writing about the interface of technology and politics, or anybody with an interest in investigative journalism. But even if one granted that despite those facts, she really was broadcasting to a true echo chamber, even more sort of closed in the style of 19th century Japan than the echo chamber the judge rejected in Sivier. Even if that is her audience, how does that answer the retweeters? Because 9,000 retweets, potentially to dozens or hundreds or thousands of followers each, is in and of itself a massive publication, larger than the circulation of a regional newspaper in this country. To say nothing of the fact, and then lastly, in this part of the judgment, she also does put emphasis on this concept of paragraph the end of paragraph 93, in my judgment, those within jurisdiction to whom the tweet was published are likely to consist of people whose opinion of the claimant was of no consequence to him. Now, in my respectful submission, that is not part of the statutory test. It doesn't matter whether or not Mr. Banks cares about people. If his reputation has been damaged, that is the test. I can see it might be that if a person really is so airily indifferent, it might perhaps go to remedy, but it does not go to the statutory test. It is completely irrelevant that Mr. Banks might think most of Cadwalladra's followers are sort of soft-minded remainers or whatever sort of pejorative thing that might be attributed to him. But in fact, the evidence was that the unchallenged evidence from Mr. Banks was that was not his view. His view. I mean, he brought this action at huge expense. And he gave direct evidence in his witness statement, which is in the third volume of the bundle. I don't ask you to turn it up given the time, but paragraphs 90 to 95, which he does say, in fact, that he was very distressed at the nature of these new allegations. And I would also say that here too, even if the judge was right to think the consequence comes into it, again, she's failed to apprehend the basic difference between merely thinking that Mr. Banks is a bit of a bad egg when it comes to Brexit and the specific single meaning which the judge, which Mr. Justice Steyn had found. Because I hope it's not thought too colourful if I reverse the facts of this case, but one might assume of the respondent herself that she may have a fairly limited regard for the stereotypical reader of the Daily Telegraph. But I venture to imagine that if the Daily Telegraph said that the respondent's writing was in fact influenced by secret payments from the European Commission, she would not think, oh, I don't care, readers of the Telegraph are of no consequence to me. It's an objectionable, in the legal sense, objectionable point by the judge, both legally because it is not part of the statutory test, and factually because it simply doesn't work in my submission, and it is contrary to uncontroverted evidence.
Does any of this matter? This is only ground two, the tweet.
Yes.
Isn't it academic, given that the judge found the public interest defence worked in relation to the tweet?
Well, not if we're well. First of all, no, because it's relevant to injunction, and secondly, it is potentially relevant to if we're right on the first ground. It is right to, in due course, whether there is a damages by way of vindication. And certainly there have been cases where statutory defences have expired, and post the expiry of the statutory defence, there's only been very limited publication. The case of Flood, for example, it's about police corruption, which is in the bundle, and very substantial damages have been awarded in those cases. But of course, that's not a case that turns on a tweet. So I can see there would be different arguments in this case, but it isn't, my lord, academic there. So it's just, if I can pull the threads together before dealing with the last point of the canter, I would also say the judge doesn't deal with all the hurtful social media reactions, which there are hundreds of them in the bundle, which we've put into the third volume for your lordships. As my lord, Mr. Justice Warby, as he was said in the Economu case, which we've seen cited elsewhere, and Mr. Justice Licklin says in Riley, although of course the statutory test is not one of whether or not you have been hurt, the existence of hurtful comments may in itself be evidence that serious harm has been suffered. And here there is an avalanche of bile, if I can call it that. It's not a mixed metaphor, in response to Ms. Cadwalladra's tweet, which again the judge doesn't even go into. So far as the appellate restraint issue is concerned, I do say this is a case where there are clear errors in reasoning. We say she takes the irrelevant into account, which is the relative publication of tweet and TED. She leaves the relevant out of account, the absolute numbers in respect of the tweets, the retweets, the likelihood of percolation, Mr. Banks's unchallenged evidence as to distress and the tweet being of consequence to him, the evidence the tweet was read by many who did not support Cadwalladr, and the many comments negative to Mr. Banks in response to the tweet which are evidence of reputational harm. The learned judge proceeds on a completely unsafe premise in respect of the echo chamber, not pleaded or addressed in the evidence, inherently implausible.
Yes, was this, I'm sorry to interrupt your flow, but you're saying that this echo chamber point was the judge's?
Well, I think it was raised in close. It was raised in
I mean,
closing.
we've seen, obviously, in the written arguments what is said by you in relation to what Mr McCormick
Yes.
said below.
Yes, and in fairness, my learned friends make clear in their skeleton they don't rely on any sort of concession by my predecessor. So I haven't really dwelt on that point. No, I'm not. But what I'm suggesting is it's something that was just it was pure assertion in argument which the judge accepted, rather than anything for which there was a safe basis in my submission. And then in developing the echo chamber analysis, she fails to give any weight to what I've suggested is a fundamental and obvious difference between, given the particular nature of the single meaning. She relies on a supposed acknowledgement by counsel, which we say for reasons in our skeleton she has misunderstood. And she has applied a mistaken legal test about whether Mr. Banks personally cared about the published sheets. So all of that's sufficient in our submission to vitiate her approach and to displace her reasoning. But if we're wrong about that, and recognising, of course, in the case of Mrs Justice Steyn, it is a very rare case of homer nodding. But we do say, without hesitation, for the reasons I've given already, that she has come to a decision which is plainly wrong, impossible to reconcile with other decisions of the King's Bench division, and indeed impossible to reconcile with the judge's own subsequent decision in Civier. And so far as my learned friends' points to the contrary are concerned, I think given the time I'd better leave them to any reply. So if I can come lastly to the TED Talk post-defence. This point clearly only arises if we're wrong on section 1, because if we're right on section 1, then serious harm is established. Well, anyway. Sorry, I've just got slightly misplaced in my notes. Yes, here we are. So far as the TED Talk is concerned, the statistics, obviously granting, as my learned friend pointed out earlier, that the statistics one does have to bear in mind some of them will be extraterritorial. But as of the date the section 4 defence ceases to apply, the TED Talk had been viewed about 3.85 million times. And you get that from the judge's table on page 78, it's paragraph 66 of the judgment. That's actually a slight overstatement because the dates don't quite marry up. So it had probably, in fact, before the expiry of the defence, been viewed a few less times on that. But let's assuming in the respondent's favour, the maximum number of protected views is 3.85 million. As of the date, the last date in the judge's table, the last dates, if you combine the YouTube and the TED, no, if you just take if you just take the TED figure, it's gone from 3.85 to 4.3. So that's an increase of 455,000 views for the unprotected period. And then in addition, the same table shows the YouTube views increased during the period of post-protection by something like 119,000 views. So you've got a minimum additional viewing of 573,690 views post-defence, which is about 1,000 views a day. In terms of future harm, there's nothing to suggest this is going to abate. And in fact, we've invited the respondent to agree these figures, but they have refused to. But as of today, TED's website indicates there have been another 123,256 views, and YouTube a further 52,398. So now around 750,000 views have taken place post-defence, which is an enormous number of publishees of this very serious allegation. It's hugely in excess of that in previous cases where scale of publication has led to serious harm simply being inferred. Now, obviously, as I've granted, not all of those views will be within the jurisdiction. On the other hand, given the title of this talk with its specific reference to Brexit, and the fact that Carol Cadwalladr has a reputation in the United Kingdom but not so widely elsewhere, it's reasonable to suppose, as the judge did, that very many of them would have been. What's the judge's approach to this? Section 9 is paragraph 97 of the judgment. It's quite compressed, but what she seems to be saying is the second line. The extent of worldwide publication from 29th of April is close to a tenth of the figure from 15th April 2019. And then she says, publication within this jurisdiction is likely to be a similarly small fraction of the total from first publication. Now, I think when some of us first read that, we thought that she was suggesting that you would infer a domestic viewership of 10%, but I don't think that is what she means, because it would be a very, very strange and unevidenced finding. What I think she means is that she is assuming that post-defence publications will be in the same ratio England and Wales to non-England and Wales as it was for the initial period. So she's essentially assuming that it is going to stand. They're going to stand in a similar relation to each other. Now, what did the learned judge find for the initial period? Well, you get that at paragraph 81. That's the paragraph my lady has already referred to, where she agrees with Mr. McCormick it's inherently probable a substantial publication in this jurisdiction at least equivalent to a high circulation domestic newspaper. So if we were to take a high circulation domestic newspaper of having a circulation of perhaps around 1 million readership, therefore of about 2 million, that is obviously a massive pre-defence expiry publication. But on the judge's remark in the paragraph we've just seen, that she assumes that the publication post-defence would be around 10% of the pre-defence. Well, 10% of the circulation of a high 10% of the circulation of a high circulation daily newspaper, or the readership of a high circulation daily newspaper, is still hundreds of thousands of people. It's certainly, we would submit, I mean, if you take the readership of a high circulation daily newspaper being 2 million, then 10% of that is 200,000. So really, on the judge's own approach, one is talking about hundreds of thousands of post-defence views, more than the readership of The Guardian itself, and far more than publications in other cases where serious harm was inferred in respect of less grave allegations. And I've already reminded you of the 50,000 viewers in the judge's own decision in Sivier, and the 10 to 15,000 in Mr Justice Micklin and Murray.
Just a small point, if I can. You doubled the circulation by applying a readership factor of 2. Where's that come from?
I was told by those who understand this area best than me, which I appreciate literally is everyone in court, that was the sort of received wisdom. But if
I'm not really trying to ask you about what the circulation and readership relationship is, but what the judge was saying, and she says in this paragraph, publication at least equivalent to a high circulation domestic newspaper. She doesn't grapple with readership. I'm not sure it's a big point.
No, I suppose I just assume that if she's saying that the publication was equivalent to the circulation.
It's a very different medium, isn't it? There are all sorts of things about Twitter that aren't really comparable with a newspaper.
Yes, well, quite. But
I'm not. The figures are very large.
I was going to say, even if I'm right on extrapolating a constant 10%, then even if the index point is 1 million or 800,000, or rather than 2 million, we're still talking about a very large-scale publication. And then I do apologise if I go on very slightly longer than I said, but I'll be as brisk as I possibly can. I just wanted then to come to the judge's reasoning. I'm just going to skip a few things because of this. So, if I can then look at her specific reasoning. Again, as with the tweet, she acknowledges in paragraph 96 the gravity is the same and the lack of direct evidence is the same. But she then goes on to say, 97, I've been persuaded on balance to draw such an inference in relation to the original publication. And then it's this figure about a tenth. But she just doesn't grapple with the fact that even at that level, one is still talking about views on a massive scale. And this can't be, and I don't really understand why she's going about, well, views would have peaked at the time of first publication, stuff like, because we've got actual data. We don't need to make any inference, as you might do with the tweet. We've got actual data about the views, and as I've said, you can see that they're ongoing post-defence at something of the order of 1,000 views a day. And she says the fact that the TED talk is on the subject of the EU referendum, which took place nearly 6 years ago, increases the likelihood that the extent of publication will continue to diminish. But I'm not sure that's entirely right either, because the talk is actually about and not just about Brexit, but it's also a future-looking talk about the impact of Facebook on politics more generally. But in any event, that's what she says. In my submission, she just doesn't deal with it's again a confusion of the relative and the absolute. She just doesn't deal with the with the scale that you're left with, even after this arresting of the increase. It may have slowed, but we're still talking about figures which in absolute terms are very significant. And they are figures, to use the judge's own words, unlike, for example, the tweet, and perhaps in some respects. As with the tweet, it's a grave allegation. But as the judge herself said, it's a serious broadcast talk by an award-winning investigative journalist on an authoritative and credible platform. Those are all the judge's descriptors at paragraph 86. Now again, on the authorities, as the court knows, one of the scale of publication is also yoked to the character of the publisher or the statement maker. And when the statement maker is a person with an ostensibly very serious reputation as an investigative journalist, and that is bolstered by the TED platform, which, as the judge found, is internationally renowned, that is, again, a considerable turbo boost, as it were, to the scale of the publication itself, before you even then get to the gravity of the tweet. So far then, as the next part of it concerned, the judge, in essence, she recapitulates on her echo chamber theory, and in our respectful submission, that has all of the vices that we've already identified in the context of the tweet, but more besides, because TED viewers cannot be casually assimilated to Cadwalladra's supporters, even if tweeters can. And absent evidence to the contrary, of which there was not a hint, the judge simply had no basis not to assume that, as my lord assumed in the Monroe case, that people that view or read the publications, even those aimed at an audience which might have a predisposition to be dogmatic, they can't be considered to be other than reasonable people. But the important thing also about the TED Talk was that on Ms Cadwalladra's own evidence, the whole reason why she was so thrilled to be invited to speak to TED was it is not directed at a dogmatic audience. I think we set out the relevant passages in our skeleton, and given that I have run out of time, that's probably the briskest way for me to deal with it. And it's really paragraph 54 of our skeleton, where we point out, and it cross-references the judgment in paragraph 81, the respondent's own evidence was that she valued her participation in TED precisely because its viewers were outside of what she called her guardian observer bubble, enabling her to reach a more mainstream audience and really filter into the domestic discussion. And when the judge goes on in 98 to say, well, I can infer that most of those within the jurisdiction who viewed the TED Talk since 29 April 2020 are like the defendant's followers on Twitter, likely to be people who are supportive of her, and likely to consist of people whose opinion of the claimant was of no consequence to him. Well, firstly, we say there's no basis for that, and again, we've got the same legal error in our submission of a test of no consequence, which again is a vitiating error of her reasoning. And really, in those circumstances, we do say that here again, there are vitiating errors of principle, but ultimately, when one looks at the scale of publication, the nature, the gravity of the statement, and the audience, the probable audience on the respective platform, it simply was outside the range of reasonable decision making for the judge to find that there was no inference of serious harm. And I do say again, if you compare and contrast, I know it's a point I've made before, but if you compare and contrast it, not just with cases of other judges, but the case supplemented by this judge, in my respectful submission, it's not too strong to say. It is the principle of appellate restraint should yield to the ability for litigants to be able to have some sort of ability with certainty to predict judicial outcomes, because you put Civier next to this case and you cannot understand how they could be the decisions of the same judge. I regret that that's a hard thing to say, and I do reiterate it. I acknowledge it immediately. It's a case of home and nodding. But those are my submissions, and I apologise to Mr. Miller for overrunning slightly.
Thank you very much.
I will, of course, take the skeleton argument as read. and I'll start with ground one and deal first of all with what I would call the issue of statutory construction and logic on ground one. The construction exercise has to be conducted according to familiar common law principles. Most importantly, obviously, first of all, there must be a laser-like focus on the words used by Parliament in the statute, and I'm going to come to that. It's something we say with respect, the other side have failed to do completely. Secondly, the Act and the words in issue in it must be read in context. What does this include? Well, it's well established it can include their legal context. What is the Act doing in terms of law and changing the law? Thirdly, the effect of the provision should accord with what the court understands is the purpose of the statutory provision. And that is the purpose generally, as it were in the abstract, across all cases. Not just a purpose tailored to an outcome a particular party in the particular proceedings arguing the construction point wants to achieve in their case, something which we say the other side have had a tendency to do in this case. Next, Parliament is assumed to know the law, including the common law. That is the principle that Lord Sumption, speaking for the Supreme Court in the show, articulated at paragraph 13 of the judgment. I don't think it's necessary to go to that, it's familiar and well known. The question here is what law is Parliament assumed to know? And the answer here is the law of tort, and in particular the defamation tort and the component elements of that. The principle concludes it's presumed not to be altering the law, that is the relevant wording in the statute, unless it's expressly stated or is a necessary implication. So, what is the wording that we're working with? It's worth having it open and focusing on it while I do the next part of the argument. It's at tab 1. Statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. And it seems to us that the contest, that is the contest about correct interpretation here, turns on what the words its publication mean in this sentence. Something I'll come to in a second. As far as context and purpose is concerned, well, the context here is this is what I would call a technical piece of legislation in a specific area of our tort law, as I've said, defamation law, which is setting out to amend, to the extent apparent on the face of the Act, the existing law in that area. As to purpose, we don't need argument because we have the benefit of the full analysis of section 1.1 of Lord Sumption speaking for the court in the show, especially at paragraphs 13 to 16, and I won't read them, we're all very familiar with them. But in essence, the purpose identified here is to require proof by evidence from a claimant that the publications, that is, those referred to in that sentence in section 1.1, whatever they are, have in fact caused serious harm to reputation, so as to ensure that only such publications can result in liability. And obviously it's not contentious that this is a provision about causation of harm, and it's not contentious that the requirement of causation of serious harm is intended to make it harder to sue on those publications. So we would say, it seems to us in contrast to the appellant, that the most important bit of the wording is the second half. That is the words after its publication, the part referring to causation of harm, which then has to be identified and assessed as either serious or not serious. And we say the key point, having got to this point in the argument, is that the concept of causation of harm here must be the concept of causation of harm in the law of tort generally, the law of defamation generally. And it is absolutely elementary that this requires harm to be caused by tortious wrongdoing. That is, flowing from the defendant's tort. There are various formulations of that in our law of tort, but essentially courts apply a but-for test, having identified the particular act or acts of wrongdoing on the part of the defendant. This is the principle that applies in the tort of defamation as well regarding harm to reputation. It's the principle that applies in the law of defamation as to the basis of any award of damages or other relief, as the judge correctly noted at paragraph 58 in the judgment. The problem with the appellant's interpretation with respect is that it completely alters that concept of causation of harm here, disconnecting it from the tortious wrongdoing, so that it's not harm flowing from the publications of the statement that are tortious. It's harm flowing from, I'll just put it neutrally at the moment, something else. Everything that is published, every publication of that statement. And therefore, on the appellant's interpretation, the harm here can be something other than that caused by tortious publication.
Mr. Miller, I'm sorry, I'm not following this line of argument, because some torts are actionable per se, but many torts are actionable only on proof of damage, in other words, harm. So the tort of negligence is not complete unless not only is there the duty of care, breach of duty established, but also harm. And so simply to show that something has caused something, it's not flowing from a tortious wrong. The tort is only complete once you have shown that the harm was caused by the breach of the duty.
Yeah, I agree, it's circular like that, but at the moment what we're looking at is simply a question of construction. How does one interpret this section? And what are the important words in the section? I'm going to come on to the opening words in the section in a moment. But if you want me to jump ahead, essentially...
No, you do it in the order you think is appropriate.
We get to Parliament gets us to a conclusion on actionability, which is the purpose of the section, in the opening words, by using, in effect, a device or a tool, which is the building on from Thornton of a higher bar for the definition of a defamatory statement. But we are focusing on the words "its publication."
Yes.
I'm not. This isn't a general exposition of how the law of tort works generally. It's an argument of construction.
I completely understand your submission is going to be about the importance of the phrase "its publication." It was only insofar as you were emphasising that caused here must be a cross-reference to the general concept of causation in the law of tort. I'm not sure I entirely follow that, but it may not be a necessary part of your argument anyway.
Well, it is because this is the context of the legislation. This is the context of the legislation. It's amending the law of defamation.
Yes.
And the law of tort in defamation.
I see.
And this is the judge's point, that you have one concept of harm. She calls it damages, damage, but it's the same thing. Being something that flows from the wrongdoing once you've established it, the tort. I agree it's circular, you've got to get to the complete tort, but that is what causation of damage is, as far as she's concerned. That's what I'm saying it is in the law of tort and the law of defamation. This line between the wrongdoing that's been proved and the harm to reputation. And necessarily their construction takes you away from that. The facts of this case and the outcome in this case is a good example of that. And my learned friend doesn't shy away from it. He says it's a very broad or blunt interpretation that we're putting forward. The question is whether it's an appropriate one for an act that's this carefully drafted that is supposed to be amending the law of tort in a particular area, that is the law of defamation. It's a big leap to say the very first section of the Act brings into play a concept of causation of harm that is different from the one that applies generally in the law of defamation. And I'm going to go on to say one sees nothing in the wording of Section 1 or anywhere else in the Act that enables you to make that leap.
So we're going to come back to the important words, its publication at 2 o'clock.
Yes, thank you.
All right.